The room didn't react the way people expect courtrooms to react when something important happens. There was no audible gasp, no rustle of papers, no sharp intake of breath rippling through the gallery. What happened instead was quieter than that. A pause, a strange, collective stillness. The kind that makes even experienced lawyers stop mid-note, not because they've been told to, but because instinct tells them something has shifted. And it happened inside the High Court. This is where the story really begins. Not with a headline, not with a verdict pulled out of context, but with silence. Because silence, in a courtroom, is often the loudest warning you get. But before we continue, please don't forget to like, subscribe, and turn on the notification bell for updates. At the center of it all sat Prince Harry, not in uniform, not on a balcony, not framed by ceremony or deference, just a claimant, a witness. A man who had raised his right hand and sworn that what he was about to say would be the truth. And here's the uncomfortable contradiction we need to sit with right from the start. This case was supposed to be about the press, about intrusion, about decades of alleged media abuse and the scars it left behind. That's the frame most people walked in with. That's the story that's been told again and again. But in that moment of silence, the focus moved, quietly, almost politely, away from the newspapers and toward the witness. If you followed Prince Harry's legal battles at all, you know this is not his first time in court. He has sued before. He has testified before. He has spoken publicly and privately about his grievances with the British press, particularly tabloids like the Daily Mail and the Mail on Sunday. He has framed those battles as moral ones, necessary ones, battles for accountability. And to be clear, this case was never about whether the coverage hurt. Pain is not on trial here. Emotion is not on trial. The court does not weigh suffering the way the public does. The court weighs words, words spoken under oath. And that's where things began to unravel. As the proceedings reached their final stages, the judge did something judges rarely do in dramatic fashion. There was no raised voice, no theatrical rebuke. Instead, there was a careful recalibration of language. Sentences that grew more precise, phrases that carried more weight than they first appeared to. Observers noticed it almost immediately. Legal correspondents leaned forward. Counsel on both sides became noticeably still. Because when a judge starts choosing words carefully, it's usually because they matter far beyond the page. This wasn't a ruling yet. Not officially, but it was something else. A signal. The case itself centered on claims against Associated Newspapers Limited, the publisher behind the Daily Mail and the Mail on Sunday. Prince Harry alleged unlawful information gathering, misuse of private data, and a sustained pattern of intrusion that he says made his and his family's lives unbearable. In court, he spoke emotionally. At times his voice reportedly broke. He described the experience as horrible for his family. He spoke about fear, about pressure, about relationships strained to the breaking point long before he ever met his wife, Meghan Markle. And if you were listening only to that, if you were absorbing the testimony as a narrative of harm, it was compelling, raw, human. But courts don't decide cases based on narrative alone. They decide them based on consistency. And consistency is where this story takes its turn. Because as the judge reviewed the evidence, the testimony, the timelines, something began to emerge. Not a single dramatic contradiction, not a smoking gun moment. Instead, a series of small misalignments. Details that didn't quite sit where they were placed. Explanations that shifted subtly depending on when they were offered. Now, before we go any further, it's important to pause here. Because this is the point where many conversations about this case become reckless. Courts do not accuse lightly. Judges do not speculate publicly. And at this stage, nothing had been declared in the way social media headlines often suggest. What had happened was narrower than that, and in some ways, more serious. The judge identified inconsistencies in Prince Harry's sworn testimony, particularly around what he knew, when he knew it, and how that knowledge related to the alleged leaks at the heart of the case. Knowledge matters under oath. Intent matters even more. The law allows for human error. Memory fades. Trauma complicates recall. Judges understand that. But when inconsistencies touch on central issues, when they intersect with claims of motive or strategy, the legal consequences shift. And this is where the room changed. Because the judge did not simply note discrepancies and move on. He addressed them. Methodically, carefully, with language that suggested the court was no longer just weighing the merits of a civil claim. It was weighing the reliability of the witness himself. If you're wondering why that distinction matters so much, consider this. A civil case can fail without consequences beyond costs and credibility. A question about testimony under oath opens a different door entirely, one that courts are extremely cautious about opening, which is why what came next landed so heavily. In the course of his remarks, the judge indicated that the inconsistencies identified might meet the threshold for something more than mere confusion or mistake. He did not say perjury in the way tabloids shout it. He didn't need to. He referenced the legal standard. He referenced the obligation of honesty under oath. And then, crucially, he referenced a process, a referral, specifically, a referral to the Crown Prosecution Service. Now, let's be very clear about what that does and does not mean. A referral is not a conviction. It is not even a charge. It is, at its core, a decision by the court that certain matters fall outside its immediate jurisdiction and warrant review by prosecuting authorities. Judges do not do this casually. They do it when they believe a line may have been crossed. And that belief alone is enough to alter everything. Reports from inside the courtroom described Prince Harry as visibly shaken as this realization set in. Not theatrical collapse. Not a dramatic outburst. Something quieter than that. A physical response to a moment that could not be spun or reframed in the usual ways. Because once a case moves beyond public relations and into prosecutorial review, control slips away. This wasn't the ending Prince Harry came for. He had asked for an apology, for accountability, for recognition of harm. What he faced instead was a judicial process that turned inward, scrutinizing not the press, but the testimony presented against it. And here's the question that hangs over everything, the one we need to ask carefully, without rushing to answer it. What happens when a man who has built his case on truth-telling is confronted not by editors, but by the court itself? Because the implications stretch far beyond this single trial. They touch future lawsuits, public credibility, the viability of ongoing legal strategies, and perhaps most importantly, the fragile boundary between lived experience and legal fact. The judge did not raise his voice. He did not accuse. He simply laid out a pathway, one that now exists whether anyone likes it or not. As proceedings concluded, the courtroom emptied the way courtrooms always do. Slowly, quietly, people filed out, speaking in lowered tones. Outside, cameras waited. Headlines were already forming. But inside that room, the story had already moved on. Because the silence that opened this chapter wasn't an ending. It was a warning. And what the Crown Prosecution Service decides to do next is only part of it. The more unsettling question is this: what else, in the testimony, is now being re-examined? And how much of this case will look different once that process truly begins? The moment the room changed. There's a strange thing that happens in courtrooms when everyone senses the same shift at once. It isn't announced. No one says it out loud. There's no formal marker in the transcript that captures it properly. But people who've spent years inside these rooms will tell you the same thing. You feel it before you understand it. That's what happened here. Up until that point, the rhythm of the hearing had been familiar. Question, answer, clarification, occasional objection. The steady, almost clinical cadence of a civil trial nearing its end. Prince Harry had already spent days on the stand. He had spoken at length about intrusion, about fear, about how relentless coverage had shaped his life long before he ever had a chance to shape it himself. Nothing about that was new. What was new was the way the judge began to speak. Not louder, not harsher, slower, measured, as if each word had been weighed before it was allowed into the room. This is where we need to pause, because so much commentary about this moment gets it wrong. People imagine some dramatic turning point. A gavel slammed, a rebuke delivered, a visible scolding. That isn't how serious judicial moments usually arrive. They arrive wrapped in restraint, in careful phrasing, in sentences that seem ordinary until you realize how much they're carrying. The judge leaned into the language of clarification. He revisited earlier testimony, not aggressively, almost conversationally, as if he were simply ensuring that everyone, the court, the parties, the record, was aligned. But alignment was precisely what was missing. He referenced specific answers Prince Harry had given days earlier. Answers about knowledge, about awareness, about what information he believed had been leaked, and when he believed he had learned it. On their own, each answer sounded plausible. Human, even. Memory is imperfect. Trauma complicates recall. Courts know this. What the judge was doing, though, was not examining each answer in isolation. He was stacking them. And when stacked, the answers didn't sit comfortably together. You could sense the change ripple outward. Lawyers who had been scribbling notes stopped. One of the barristers glanced up, pen hovering just above the page. Members of the press leaned forward almost in unison, not because something explosive had been said, but because something precise had. Precision is dangerous in court. It leaves very little room to maneuver. Prince Harry, for his part, remained composed, at least outwardly. He listened. He nodded slightly at points. He adjusted in his seat. Nothing that would stand out to an untrained eye. But those who were watching closely noticed the micro shifts. A tightening of the jaw. A longer pause before answering. The subtle recalibration that happens when someone realizes the ground beneath them isn't quite as stable as they thought. The judge wasn't accusing him of lying. Not yet. He didn't need to. Instead, he focused on what the court calls internal consistency. Whether a witness's account remains coherent when examined across time, context, and documentation. And this is where the story moves away from headlines and into mechanics. Because civil courts deal with claims, but they rely on testimony. And testimony, once given under oath, becomes evidence in its own right. It's no longer just a story being told. It's a representation of fact that the court must be able to trust. The judge noted, carefully, that there were discrepancies between Prince Harry's witness statement and his oral evidence. Not contradictions in the dramatic sense. No single sentence that exploded the case. Instead, subtle differences in emphasis, in framing, in what was acknowledged at one point and downplayed at another. For example, the question of private knowledge. Prince Harry's case depended, in part, on the assertion that certain information could only have come from unlawful intrusion. That he could not have known it would be published. That its appearance in print was, by definition, evidence of wrongdoing. But during testimony, moments emerged where his own words suggested awareness, not of publication, but of internal conversations, private disclosures, or circulating information within his own environment. The distinction matters. A great deal. The judge didn't spell this out in dramatic terms. He didn't need to. He simply asked for clarification. And clarification is where things get dangerous. Because clarification forces a witness to choose, to reaffirm, to refine, to potentially narrow an earlier statement in a way that exposes its fragility. Prince Harry answered, calmly, thoughtfully, but the answers didn't quite close the loop. At one point, the judge paused longer than before. Long enough that the silence itself began to feel like part of the proceedings. He looked down at his notes, then back up. This is when seasoned court watchers knew something had shifted. Because judges don't pause like that unless they're deciding how much to say. He began to speak again, this time referencing the standard expected of any witness under oath. Not a prince, not a public figure, any witness. The obligation to tell the truth, yes, but more specifically, the obligation not to mislead the court, even indirectly. Misleading doesn't require malice in the way people think it does. In law, it can arise from selective disclosure, from framing that omits critical context, from answers that are technically accurate but materially incomplete. The judge's words were restrained, almost gentle, but they landed. Prince Harry's legal team remained silent. There was no objection, no interruption, because objecting at that moment would have only drawn more attention to the point being made. And here's where the emotional layer begins to complicate things. Prince Harry had spoken openly about the toll this case had taken on him and his family, about the pressure it placed on relationships long before Meghan entered his life, about the fear that coverage would escalate into something worse. He spoke about his past relationship with Chelsea Davy and how media narratives contributed to strain, distrust, and eventual collapse. All of that may be true in an emotional sense, but courts don't adjudicate emotional truth. They adjudicate factual alignment. And the judge was making it clear, again, without raising his voice, that emotional conviction does not substitute for evidentiary coherence. This is the moment many people later described as the point where Prince Harry seemed to falter. Not because he collapsed physically, but because the certainty he had carried into the courtroom appeared to waver. He was no longer simply telling his story. He was responding to the court's interpretation of it. That's a very different position to be in. The judge then referenced the record, the written submissions, the timelines. He didn't accuse Prince Harry of fabrication. He said something more troubling than that. He suggested that the inconsistencies identified could not be resolved through clarification alone. That's legal language with teeth. It means the court believes the issue may sit outside the scope of the civil case itself. And when that threshold is crossed, the consequences escalate. At this point, the atmosphere in the room had changed entirely. What had begun as a discussion about journalistic practices was now orbiting a different center. The integrity of testimony, the sanctity of oath. Prince Harry reportedly lowered his gaze briefly, not in defeat, more like concentration, as if trying to replay the past answers in his head, searching for the version that would align them all. But courts don't allow rewinds. The judge then did something that, in hindsight, marked the true turning point. He referenced the possibility, carefully framed, conditional, but unmistakable, that the matter might require consideration beyond his own courtroom. He didn't name it outright at first. He spoke about process, about duty, about the responsibility of the court to act when certain standards appear to have been breached. Only later did the term referral surface, and when it did, it landed with weight. Because everyone in that room understood what it implied. Not certainty, not guilt, but scrutiny at a level that no longer bends to narrative or sympathy. Prince Harry's reaction was subdued but visible, shoulders slightly slumped, breathing measured, the kind of composure that takes effort, not collapse, but containment. Outside the courtroom, the world was still catching up. Social media was still speculating. Headlines were still forming. Inside, the consequences were already unfolding. This was no longer just about what the press had done. It was about what had been said, and whether it could withstand the most unforgiving standard there is. An oath. The judge concluded his remarks without flourish. He did not sensationalize the moment. He simply closed the door on one phase of the case, and, in doing so, opened another. As the session adjourned, there was no dramatic exit. Prince Harry stood, gathered his papers, left the room as he had entered it. But something fundamental had changed. Because once a judge signals that testimony itself may warrant external review, the narrative shifts permanently. From claimant to witness, from victim to participant, from story to scrutiny. And the question that now looms isn't whether the press crossed lines. It's whether the court believes the line of truth itself was crossed. And if so, what happens when that judgment leaves the courtroom and enters the hands of prosecutors? Because the moment the room changed wasn't the end of this chapter. Here's where a lot of people, even smart observers, lose the thread. They assume this case turned because the judge suddenly turned on Prince Harry, or because the court stopped caring about press misconduct, or because emotions somehow backfired. None of that is quite right. And if you don't understand what the court was actually deciding in that moment, everything that follows can feel confusing, even unfair. So let's slow this down. Because the real shift in that courtroom had nothing to do with sympathy, status, or spectacle. It had to do with scope. Civil courts are narrow by design. They are not truth commissions. They don't exist to validate a person's lived experience in full. They exist to answer specific questions, using specific standards, within defined legal boundaries. And up until that point, the court's task seemed clear enough. Determine whether Associated Newspapers limited unlawfully obtained or misused private information in relation to Prince Harry. That's it. But here's the part that rarely gets explained properly. Courts cannot answer that question in a vacuum. They have to evaluate how claims are constructed, how evidence is presented, and critically, how testimony supports or undermines the theory of wrongdoing. Which means the court wasn't just deciding what the press did. It was deciding whether the explanation offered by the claimant could logically sustain the allegations made. And that's a much colder exercise than most people expect. In simple terms, the judge wasn't asking, was Prince Harry hurt? He was asking, does the evidence, including sworn testimony, coherently support the conclusion that unlawful activity occurred? That distinction matters more than anything else in this case. Because once the judge began to doubt the coherence of the explanation, the case didn't just weaken. It changed category. At that point, the court's responsibility expanded. Judges are not passive listeners. They are guardians of process. If, in the course of a civil trial, a judge believes testimony may have crossed from inconsistency into potential misrepresentation, the court cannot ignore that simply because it's inconvenient or uncomfortable. In fact, the more prominent the witness, the less likely the court is to look away. Equality before the law isn't just a slogan. In practice, it means that a sworn oath carries the same weight regardless of who takes it. And Prince Harry knew that when he entered the witness box. This is where intent becomes the quiet centerpiece of everything. Because courts recognize three very different categories of problematic testimony. First, simple error, misremembered dates, confused sequences, gaps caused by time or trauma. These are common. Judges expect them. Second, inconsistency without clear motive. Statements that don't quite line up, but don't obviously benefit the witness either. These raise questions, but they're usually resolved through clarification. The third category is where things become serious. That's when inconsistencies appear to support a strategic narrative. When shifting explanations align too neatly with the needs of the case. When what is emphasized or omitted changes depending on what strengthens the claim. That's the category the judge was circling. Not accusing, not declaring, circling. And here's the part that's uncomfortable to acknowledge. Prince Harry's case, by its nature, required him to present himself as someone largely unaware of certain information until it appeared in print. His claims of unlawful intrusion relied on the idea that the press could only have known these details through improper means. That's a perfectly legitimate legal theory. But it collapses if the witness appears to have had prior awareness of how, when, or why that information existed. Not awareness of publication, awareness of origin. And the judge had noticed moments where Prince Harry's own testimony complicated that distinction. Again, not in a single explosive answer, but across days of evidence. That's why the judge's focus wasn't on whether articles were distressing or unfair. It was on whether the mechanism by which those articles came into being could be credibly attributed to unlawful conduct, given what the claimant said he knew privately. If you're asking yourself why this feels so technical, it's because it is. And that's exactly why it's dangerous. Technical issues don't generate public outrage right away. They don't trend well, but they are the ones that quietly reshape cases. At one point, the judge referenced the idea of material relevance. That phrase doesn't sound dramatic, but it's loaded. It means that certain details aren't peripheral. They go to the heart of the claim. When a witness's account of those details shifts, even slightly, the court has to ask why. Was it memory? Was it misunderstanding? Or was it narrative pressure? This is where Prince Harry's emotional testimony, however genuine, became a double-edged sword. Because emotion can reinforce credibility, but it can also mask precision. Courts are trained to separate the two. The judge acknowledged, explicitly, the distress described. He did not dismiss it, but he also made clear that distress does not excuse inaccuracy under oath. That's not cruelty. That's law. And this is where the judge's role changes from neutral arbiter to something more active, not adversarial, but protective of the system itself. Because if courts allow emotionally compelling testimony to override evidentiary standards, the system collapses. So what the judge was actually deciding, in that moment, was not whether Prince Harry's pain was real. He was deciding whether the court could rely on Prince Harry's account as a stable foundation for serious allegations. And once that question is raised, it doesn't stay contained. There's another layer here that rarely gets discussed, but it matters enormously. Prince Harry is not just any claimant. He is a public figure engaged in multiple ongoing and potential legal actions. His credibility in one case inevitably echoes into others. Judges are aware of that. They don't ignore it, but they don't act on it lightly either, which is why the language used mattered so much. The judge did not say, "I find this witness unreliable." That would have ended the civil case decisively. Instead, he used conditional language. He spoke about concerns, about questions that cannot be resolved within this forum. That phrase, "within this forum," is doing a lot of work. It signals that the court recognizes limits, that some issues, once raised, belong elsewhere. And that's where the idea of referral enters, not as punishment, not as condemnation, but as procedural necessity. When a judge believes sworn testimony may warrant further examination, the court is obligated to act. Not because it wants to, but because failing to do so undermines the integrity of the oath itself. Think about that for a moment. The oath is the backbone of the entire system. If courts selectively enforce it, credibility becomes optional. And that's not a world any judge wants to preside over. So when the judge referenced the potential involvement of the Crown Prosecution Service, it wasn't dramatic escalation. It was containment. A way of saying, this issue is bigger than this case, and it must be handled by the proper authority. That's why the courtroom felt different after those words were spoken, because everyone understood that the case had split into two tracks. The civil claim would continue on its path, but the testimony itself had taken on a life of its own. Prince Harry's legal team, notably, did not protest this framing. They did not argue that the judge was overreaching. That silence was telling, because lawyers know when to fight and when fighting would only deepen the problem. For Prince Harry, this was the moment where the familiar terrain of public narrative gave way to something far less controllable. No amount of explanation outside the courtroom could undo what had been said under oath inside it. And that's the central tension that now defines this story. Not whether the press behaved badly, but whether the court believes the explanation offered in response was fully, materially, and consistently true. The judge ended this phase of his remarks by returning, briefly, to first principles. The role of the court, the seriousness of sworn evidence, the necessity of trust. It wasn't a speech. It was more like a reminder. And reminders, in law, are rarely casual. As the parties prepared to move forward, there was a sense that something irreversible had occurred. Not a verdict, not a judgment, but a reclassification of risk. Prince Harry had entered the courtroom seeking accountability from the press. He left it facing accountability of a different kind. And the question now, the one that will define everything that follows, is this. What happens when a court decides it can no longer resolve the most important issue on its own? Because once that decision is made, the story stops being about headlines and starts being about process. And process has a way of moving forward, whether anyone is ready for it or not. Here's the thing about sworn testimony that most people don't appreciate until they see it tested in real time. A moment where Prince Harry said one thing on Monday and the opposite on Tuesday. You would have missed the real problem entirely. There was no cinematic gotcha, no audible intake of breath from the gallery, no lawyer springing to their feet in triumph. What there was instead was drift, small shifts in emphasis, slight changes in framing, answers that were defensible on their own, but awkward when placed side by side. That's why the judge didn't interrupt immediately. He let the testimony breathe. He allowed it to unfold across days. Because coherence isn't tested in isolation. It's tested over time. Prince Harry's account was emotionally consistent. That's important to say up front. The sense of distress, pressure, and long-term strain never wavered. His description of feeling hunted by the press, of relationships buckling under scrutiny, of a life shaped by intrusion, that through line held. But emotional consistency is not the same as factual alignment. And the court was not measuring pain. It was measuring precision. The trouble began with what seemed like minor clarifications. Questions about when certain details were first known, whether specific pieces of information were already circulating privately before publication, how Prince Harry understood the source of particular stories at the time they appeared. None of this sounded explosive. In fact, to a casual listener, it might have sounded like the kind of procedural tidying up that happens in every trial. But the judge wasn't tidying. He was mapping. He was looking for a stable timeline, a version of events that remained internally consistent regardless of how the question was asked. And that's where the answers began to wobble. In earlier statements, Prince Harry had suggested that certain articles could only have been published through unlawful means. That the information they contained was private, tightly held, and unknown outside a very small circle. This framing was central to the claim. It wasn't rhetorical. It was structural. Later, under questioning, his answers introduced nuance. Not contradictions, exactly. More like qualifiers. Acknowledgments that some details may have been discussed informally. That certain assumptions were made at the time. That awareness developed gradually rather than all at once. Each answer, taken alone, made sense. Together, they raised a question the court could not ignore. If information was known, even partially, within private networks before publication, the causal chain between publication and unlawful intrusion becomes less certain. And courts don't deal in certainty the way public debate does. They deal in thresholds. At one point, the judge returned to a specific example, not to embarrass the witness, not to trap him, but to anchor the discussion. He referenced Prince Harry's understanding of how a particular personal detail might have reached journalists. The answer given earlier suggested surprise. The later answer suggested resignation. Not outrage, but acceptance that information had a way of spreading. Again, not dramatic, but revealing. Because surprise and resignation imply very different states of knowledge. The judge didn't accuse Prince Harry of changing his story. He asked him to reconcile it. And reconciliation is harder than denial. Prince Harry tried. He explained the emotional context, the confusion of the period, the cumulative toll of years of coverage. He spoke about how, at the time, everything felt intrusive, everything felt unsafe, and lines between private and public blurred. That explanation was human, but the judge wasn't asking about feelings. He was asking about facts. And here's where the courtroom tension thickened. Because the more Prince Harry leaned into emotional explanation, the more it became clear that the court was looking for something else. Something colder, something firmer. Dates, sequences, awareness. The judge began to reference documentation, emails, statements, records that placed certain knowledge earlier than the narrative suggested. Not conclusive proof of wrongdoing by the witness, but enough to complicate the clean version of events the claim relied upon. This is where the word misalignment started circulating quietly among reporters. Not lie, not fabrication. Misalignment. It's an innocuous word, but in legal contexts, it's a warning sign. It suggests that the story being told may be drifting away from the evidentiary anchor points that support it. Prince Harry remained calm throughout this phase. That's worth emphasizing. There was no visible anger, no collapse. If anything, there was concentration. The look of someone trying to hold multiple versions of the past in their head at once and find the one that fits. But courts don't allow witnesses to choose the version that feels truest. They require the version that aligns most closely with verifiable reality. The judge returned, again and again, to the same axis: knowledge and timing. What was known, when it was known, and how that knowledge shaped the assumptions underlying the claim. At one point, Prince Harry acknowledged that his understanding of how information reached the press evolved over time. That at the time of publication, he may have believed one thing, and later came to believe another. That admission, in a different context, might have been unremarkable. People reassess the past all the time. But under oath, evolution creates problems. Because testimony is not a memoir. It's not retrospective interpretation. It's a sworn account of fact as understood at the time relevant to the claim. The judge seized on that distinction, gently but firmly. He asked whether Prince Harry was testifying about what he believed then, or what he believes now. It's a deceptively simple question, and it's one that stopped the room. Because the answer determines whether the testimony is evidentiary or interpretive, courts accept the former. They are wary of the latter. Prince Harry answered carefully. He acknowledged the difficulty of separating those things, of disentangling the emotions and assumptions of the time from the clarity that comes later. That honesty was disarming, but it was also dangerous, because acknowledging that difficulty implicitly concedes that earlier statements may have been framed through a lens that no longer applies. And that's when the judge shifted again. He reminded the court and the witness that while memory can be imperfect, sworn testimony requires an effort to distinguish between contemporaneous belief and retrospective understanding. It wasn't a reprimand. It was a boundary. And boundaries, once drawn, have consequences. The cumulative effect of these exchanges was subtle but unmistakable. The judge was no longer just evaluating whether Prince Harry's account supported his claims. He was evaluating whether the account itself could be relied upon as evidence. That's a different question entirely. And once that question is on the table, everything else becomes secondary. The atmosphere in the courtroom reflected this shift. The earlier tension, the kind that comes from adversarial questioning, gave way to something quieter, a sense of recalculation, of legal teams reassessing where they stood. Prince Harry's counsel did not intervene. They allowed the answers to stand. That, too, was telling. Because interrupting at that stage would not have undone the concern. It would have amplified it. Instead, the testimony continued. And with each answer, the gap between emotional narrative and evidentiary precision became more pronounced. This is where many people later misinterpreted what happened next. Reports began to circulate about Prince Harry being caught out, about his testimony falling apart. Those are crude descriptions, inaccurate ones. What actually happened was more unsettling. The testimony didn't fall apart. It refused to lock into place. And courts are deeply uncomfortable with narratives that won't settle. Because a narrative that won't settle suggests unresolved issues. And unresolved issues under oath don't simply disappear when a case concludes. The judge, having allowed the process to unfold fully, finally articulated the concern that had been building. He said carefully that the inconsistencies identified could not be resolved through further questioning within the confines of the current proceedings. That sentence did a lot of work. It acknowledged that the court had tried, that it had given the witness space to explain, clarify, reconcile, and that, despite those efforts, something remained unresolved. At that moment, Prince Harry's posture changed slightly, not dramatically, just enough to be noticed by those watching closely. A subtle sag. A breath taken a fraction too late. Because unresolved issues under oath carry weight. They don't end with the witness stepping down. They linger. The judge did not accuse Prince Harry of deliberately misleading the court. He did something more consequential than that. He suggested that the question of whether the testimony met the required standard might need to be assessed elsewhere. Not here, not now, but somewhere with a different mandate. And once that suggestion enters the record, it cannot be unheard. Because it reframes everything that came before. What began as a civil dispute about press behavior had, through the accumulation of small misalignments, become a question about the reliability of sworn evidence. And that is a line courts take very seriously. As the day drew to a close, the courtroom emptied again. Slowly, quietly. Outside, speculation intensified. Inside, the consequences were already crystallizing. The testimony that wouldn't line up had done more than complicate a case. It had triggered a process that now exists independent of intent, emotion, or narrative. Because under oath, it's not enough to be sincere. You have to be consistent. And once the court begins to doubt that consistency, the story stops being about what happened to you and starts being about what you said, and whether it can withstand scrutiny far beyond this room. Under oath, why intent changes everything. There's a misconception about oaths that's hard to shake. People think an oath is about sincerity, about whether someone meant what they said, about whether they were speaking from the heart. That's how oaths are treated in public life, as moral pledges, symbolic gestures, declarations of honesty. In court, an oath is something else entirely. It's a legal instrument. And once that instrument is engaged, intent stops being abstract and starts becoming decisive. This is where the case crossed into territory that even experienced observers found unsettling. Because the judge was no longer interrogating memory. He was interrogating purpose, not motive in the dramatic sense. No one was suggesting a grand scheme or deliberate deception in the way people imagine it. The focus was narrower, sharper, and far more consequential. Did the witness understand what he was saying when he said it? Did he appreciate how his words functioned within the claim he was advancing? And crucially, did the way those words were framed materially shape the court's understanding of the alleged wrongdoing? These are not emotional questions. They are mechanical ones. And courts are unforgiving when mechanics start to fail. The judge returned to the oath itself, not theatrically, almost academically. He reminded the room that an oath does not merely require a witness to avoid outright falsehoods. It requires them not to mislead, even indirectly, even unintentionally, if the effect is material. That's the part that often shocks people. Because in everyday life, we tolerate a lot of ambiguity. We tell stories. We compress timelines. We emphasize what mattered to us and blur what didn't. None of that feels dishonest. It feels human. Under oath, that instinct becomes dangerous. Because the court is not asking for the version of events that feels truest to the witness. It's asking for the version that most accurately reflects what was known, when it was known, and how that knowledge informed specific actions or claims. This is where intent enters quietly but decisively. Intent doesn't mean malice. It doesn't require a witness to have sat down and decided to deceive. In legal terms, intent can exist in the way testimony is shaped. in what is foreground, what is minimized, and what is framed as assumption rather than fact. The judge made this clear through example rather than accusation. He spoke about the difference between saying, "I did not know," and saying, "I did not believe." On the surface, those phrases can feel interchangeable. In court, they are not. "I did not know" is a factual assertion about the absence of information. "I did not believe" is a statement about interpretation. If a witness substitutes one for the other, even unconsciously, the effect on the court's understanding can be profound. Prince Harry's testimony, at various points, appeared to slide between those modes, sometimes describing absence of knowledge, sometimes describing disbelief or distrust. The distinction is subtle, but legally crucial. The judge wasn't suggesting this was done with bad faith. He didn't need to, because the effect is what matters. If the court is led to conclude that information could only have been obtained unlawfully, based on how testimony is framed, and that framing later appears unstable, the integrity of the process is at risk. That's when intent becomes unavoidable. Not intent to lie, intent to present a narrative in a particular way. And that's a line courts watch closely. This is why the judge spent so much time disentangling contemporaneous understanding from retrospective interpretation. It wasn't pedantry. It was risk management. Courts understand that people reinterpret their past through the lens of later experiences, especially experiences involving trauma, betrayal, or prolonged conflict. That's human. But when those reinterpretations are presented as factual recollections under oath, the court has to intervene. Because reinterpretation can unintentionally mislead, and misleading the court, even without malice, carries consequences. The judge illustrated this with a hypothetical, not directly tied to the facts, but close enough that its relevance was unmistakable. A witness believes, at the time, that a door was locked because it felt locked. Years later, evidence emerges suggesting it wasn't. If the witness testifies under oath that the door was locked, based on belief rather than verification, the testimony is inaccurate, even if sincerely held. The court isn't judging sincerity. It's judging accuracy. Prince Harry listened intently during this explanation. Those watching described a shift in his focus. Less narrative, more analytical, as if he was realizing, in real time, that the court was operating on a different plane than public discourse. This is where the emotional weight of the case became almost irrelevant. Not because it didn't matter, but because it couldn't change the standard being applied. The judge acknowledged, again, the distress described. He did not dismiss it. But he made clear that distress cannot retroactively alter what was known at the time relevant to the claim. That sentence landed hard, because it quietly stripped the testimony of its most persuasive shield. Emotion can contextualize actions. It can explain reactions, but it cannot substitute for factual precision. And now we arrive at the most consequential part of this chapter. The judge began to address what happens when testimony appears to cross from imprecision into potential distortion. He did not say it had crossed that line. He said the court could not determine that question conclusively within the confines of a civil trial. That distinction matters. Civil courts are not designed to investigate the mental state of witnesses beyond what is necessary to resolve the claim before them. They do not conduct criminal inquiries. They do not determine guilt beyond reasonable doubt. When questions arise that implicate the integrity of sworn evidence itself, the court has two options. Ignore it, or refer it. Ignoring it undermines the oath. Referring it preserves the system. That's the framework the judge was operating within. And that's why the mention of a potential referral to the Crown Prosecution Service was not an escalation in tone, but a narrowing of responsibility. The judge was essentially saying, "This issue may exist, but it is not for me to resolve it here." That is a heavy statement, because it means the court has identified a question serious enough to warrant independent review, but restrained enough not to prejudge the outcome. Prince Harry's reaction at this point was described as subdued, not shocked, not indignant, more like someone absorbing a reality that cannot be negotiated with. Because once intent is questioned at this level, explanations lose their power. You cannot explain intent away. You can only have it assessed. An assessment follows rules that are far less forgiving than public opinion. This is where the narrative many people expected, a battle between a prince and the press, quietly collapsed. Because the court was no longer focused on the press. It was focused on the oath. The judge closed this portion of his remarks by returning to the principle that governs all sworn evidence. The court must be able to rely on it. Not partially, not conditionally, fully. If reliance is compromised, even by uncertainty, the court must act. He did not say what would happen next. He did not speculate. He simply stated that the matter could not end there. That restraint was deliberate, because once intent is in play, silence becomes procedural. And the silence that followed was different from the one that opened this story. This wasn't the quiet of anticipation. It was the quiet of consequence. As the courtroom adjourned, there was a palpable sense that the case had entered a phase no one could script. The familiar rhythms of litigation gave way to something more open-ended, more procedural, more dangerous. Prince Harry left the courtroom not as a defeated man, but as a man facing a process that no longer revolved around his narrative. Intent had shifted the axis, and once that axis shifts, everything else begins to orbit differently. Because the question is no longer what happened to you, it's what you meant when you spoke, and whether the law believes you understood the difference. The referral no one was expecting. Referrals don't arrive with drama. That's the first thing to understand. They don't come with sirens, or announcements, or language designed to provoke a reaction. In most courtrooms, a referral is introduced the way a surgeon introduces a risk. Clinically, cautiously, and only after every other option has been exhausted. Which is why so many people missed what was happening in real time. Because when the judge began to outline the possibility that certain aspects of the testimony might require review beyond the civil court, he didn't frame it as punishment. He framed it as procedure, as obligation, as something the court does not choose lightly, but cannot ignore. And that distinction is everything. Up until that moment, Prince Harry's case had followed a recognizable arc. A claimant challenging powerful media organizations. A narrative of long-term harm. A reckoning with tabloid culture. However complex or contentious, it still fit within the boundaries of civil litigation. The introduction of a referral changed that geometry completely. Not because it guaranteed anything would happen next, but because it acknowledged that something might. And in law, acknowledging that possibility is a threshold event. The judge did not say, "I am referring this matter." Not yet. He did something more subtle, and arguably more consequential. He stated that certain inconsistencies identified during sworn testimony could fall within a category that is not for a civil court to determine. That phrasing matters. Civil courts resolve disputes between parties. They weigh evidence to decide liability. They do not investigate whether a witness has committed an offense. That responsibility lies elsewhere. When a judge signals that a line may have been crossed, even tentatively, the court is obliged to consider whether to pass the matter on to the appropriate authority. That authority, in England and Wales, is the Crown Prosecution Service. Now, let's pause here, because this is where public understanding tends to collapse into panic or denial. A referral to the CPS does not mean charges will be brought. It does not mean a crime has been committed. It does not mean guilt has been established. In many cases, referrals result in no further action at all, but they are never meaningless. A referral means the court has determined that the question raised is serious enough to warrant independent review under criminal standards. Standards that are far stricter than those applied in civil proceedings. And that alone changes the stakes. Inside the courtroom, the mention of a potential referral landed with an audible shift in attention. Not noise, attention. The kind that tightens posture and stills movement. Because everyone present understood what the judge was really saying. This case might not end where it began. The judge's reasoning was careful. He emphasized that the court was not making findings of criminal liability. He stressed that it was not his role to do so. But he also made clear that the integrity of sworn testimony is foundational to the justice system. And when questions arise about that integrity, they cannot simply be set aside for the sake of expediency. This wasn't about Prince Harry as a person. It was about the oath as an institution. And institutions tend to protect themselves. Observers noted that Prince Harry appeared to register this shift almost immediately. Again, not dramatically. No outburst. No visible collapse. Instead, a kind of inward turn. A recalibration. The look of someone realizing that the terrain has changed in a way that cannot be negotiated with words. Because referrals operate on a different clock, they are not driven by public pressure. They are not shaped by narrative. They are administrative, procedural, and opaque by design. Once initiated, they move at the pace of review, not reaction. And crucially, the person referred has no control over whether that review proceeds. That loss of control is often the hardest part to process. Up until now, Prince Harry had been the driver of this litigation. He chose to bring the case. He shaped its claims. He framed its narrative. Even when challenged, he retained agency over how he responded. A referral removes that agency. It hands the question to a body whose sole task is to decide whether the legal threshold for further action is met, not whether the witness is sympathetic, not whether the harm described is real. Only whether the evidence, taken as a whole, suggests that an offense may have occurred, and that evaluation is brutally narrow. The judge's comments made clear that the potential referral was not about the entirety of Prince Harry's testimony. It was about specific inconsistencies, particularly where those inconsistencies intersected with central claims about knowledge and causation. In other words, this wasn't a broad indictment. It was a targeted concern. And targeted concerns are often more dangerous than sweeping ones, because they're easier to investigate. The judge noted that such matters, if pursued, would be assessed independently and impartially. He did not speculate on outcomes. He did not suggest inevitability. He simply acknowledged the process. That restraint was deliberate. Judges are acutely aware of the weight their words carry, especially when referring to potential criminal scrutiny. Overstatement can prejudice future proceedings. Understatement can undermine accountability. Walking that line requires precision, and the judge walked it carefully. Still, the effect on the room was undeniable. Legal teams exchanged brief, unreadable looks. Journalists began mentally rewriting their copy, not because they had been given a headline, but because they understood that the story had acquired a new axis. This was no longer just about what the press had done. It was about what the court might do next. And that possibility reframed everything that had come before. Prince Harry's emotional testimony, which had dominated coverage earlier in the trial, suddenly receded in importance. Not because it was dismissed, but because it was no longer the focal point. The focal point was process. Specifically, whether the court had a duty to initiate one. This is where misunderstanding flourishes. Some people interpreted the judge's remarks as an attack. Others as vindication of long-held skepticism. Both missed the point. The court was not taking sides. It was drawing a boundary. It was saying, this question exceeds my remit. And when a court does that, it is effectively acknowledging that the system has safeguards that operate beyond individual cases. Those safeguards exist to preserve trust. Because if sworn testimony can be strategically framed without consequence, the oath becomes symbolic rather than substantive. And courts cannot allow that. For Prince Harry, this was the moment when the narrative he had carried for years encountered an institutional limit. Not rejection, not endorsement, a limit. The judge concluded this portion of his remarks by reiterating that any further action would follow established procedures, that no assumptions should be made. That fairness applies to all. Those words were not reassuring in the way people expect reassurance to sound. They were procedural, neutral, almost cold. But neutrality, in this context, is power. As the session drew to a close, the courtroom atmosphere remained subdued. There was no rush, no dramatic exit. People filed out as they always do, but with a heightened sense of awareness, as if everyone understood that the most consequential part of the case might not be the verdict itself, but what happened afterward. Outside, commentary quickly began to polarize. Some framed the moment as collapse, others as overreach. Very few paused to consider the reality. Referrals are neither conclusions nor accusations. They are questions, and questions, once formally asked, do not simply fade away. They move forward, quietly, relentlessly. Prince Harry left the courtroom that day still a claimant in a civil case. But he also left as a witness whose words had triggered a mechanism beyond his control. That duality is uncomfortable, because it forces a reckoning not just with what was said, but with how it was said. And why? And the most unsettling part of all is this. The referral, whether pursued or not, now exists independently of public opinion. It is no longer about winning or losing. It is about review. And review follows its own logic. Because once the court signals that sworn testimony may require external scrutiny, The story is no longer confined to one courtroom, one judge, or one verdict. It becomes systemic, a pattern the court couldn't ignore. Patterns don't announce themselves. They don't arrive neatly labeled or fully formed. In court, patterns emerge the way condensation forms on glass, gradually, almost invisibly, until suddenly you realize the surface has changed. That's where this case now was. By the time the judge began to speak in terms of process rather than outcome, the courtroom had already moved past individual answers, past single moments of uncertainty. What the court was grappling with now was accumulation, not one inconsistency, several. Not a contradiction, a shape. This is the part of the story that tends to get flattened in public retellings, because it's harder to dramatize. A single lie is easy to understand. A pattern of narrative adjustment is not. It requires patience, attention, and a willingness to accept that the most consequential shifts often happen without spectacle. The judge had spent days listening. That matters more than people realize. Judges don't skim testimony. They don't rely on impressions. They listen for repetition, for drift, for how answers evolve when pressure changes. They note what stays constant and what adapts. And by the time this case reached its later stages, the judge had heard enough to begin comparing not just what Prince Harry said, but how he said it over time. The emerging concern was not that Prince Harry's account was wildly inconsistent. It was that it was selectively consistent. Certain elements remained fixed. The sense of persecution, the emotional toll, the belief that the press operated with hostility and recklessness. Those threads never wavered. Other elements, however, appeared more fluid, particularly those that touched on knowledge, awareness, the internal mechanics of how information moved before it appeared in print. At times, Prince Harry spoke as though publication itself was the first moment of revelation, as though the articles landed without warning, carrying information that could only have come from unlawful intrusion. At other times, he acknowledged private conversations, circulating assumptions, or internal awareness that complicated that picture. Again, none of this was outrageous in isolation, but the court was no longer dealing with isolation. It was dealing with repetition. The judge began to reference earlier exchanges, not to trap the witness, but to test stability. He returned to themes rather than statements. How did Prince Harry describe his understanding of events on day 1 compared to day 3? How did his framing shift when questions moved from general experience to specific instances? These are not hostile techniques. They are evaluative ones. And the evaluation was revealing something uncomfortable. There was a pattern of amplification and retreat. When discussing the emotional impact of coverage, the narrative expanded. Details flowed. Context deepened. The story grew richer. When discussing the mechanics of knowledge, who knew what, when, and through which channels, the narrative contracted. Answers became narrower, more qualified, more cautious. That asymmetry matters, because courts look for symmetry between claim and explanation. When a claim relies heavily on a particular factual premise, the explanation supporting that premise needs to be equally robust. In this case, the factual premise was that certain information could only have been obtained unlawfully. That premise was doing a lot of work, and the court needed to be confident it was sound. The judge's concern was not that Prince Harry had fabricated experiences. There was no suggestion of invented harm. The concern was that the explanatory framework connecting that harm to unlawful conduct appeared to shift depending on context.